What are some of the pros and cons of a transfer on death deed? The pro is that a transfer on death deed is relatively easy to execute and can be done quickly. It can transfer a piece of real estate upon your death to your intended heirs or beneficiaries. However, some of the cons of a transfer on death deed is it does not provide you with other protections during life like a revocable living trust and a durable power of attorney would do. For instance, a transfer on death deed will not help you in terms of avoiding a guardianship. It only becomes effective upon your death. Therefore, if you're alive but incapacitated, the people named on the deed have no authority to manage or transfer the property during your life. Second, a transfer on death deed can lead to problems if you leave the real estate to multiple beneficiaries. Upon your death, they just become co-owners of the property. So if you have 5 children and you leave it to them, there's 5 children suddenly own a 1/5 interest in that house or real estate. Within a will, you can name a personal representative who's in charge of selling the house and wrapping up the estate. Or in your trust, you can name the trustee to manage it. But a transfer on death deed doesn't name any one of those 5 children as in charge. This can lead to strife and sometimes fights over what to do with the property. In the worst case, it could lead to a partition sale or a court fight. So think carefully about the situations where you use a transfer on death deed. They can be a very effective tool as part of a comprehensive estate plan. Talk with your attorney about whether it makes sense for you.